All right, question number 24. In the context of a Article 78 proceeding, the term body or officer means and includes, and this says a court, tribunal, board, corporation, or officer. It doesn't say union, but I'm not sure why it doesn't say union, but I actually even tried Googling it, couldn't find anything. 25. Information subpoena served pursuant to 5224 shall contain a certification signed by the judgment creditor or its attorney stating in sum and substance that to the best of its knowledge, information, and belief, the entity or person receiving the subpoena has relevant information about the debtor. Without this document, subpoena shall be deemed null and void. 26. 7009. I think I already did this one, but it's basically saying notice before hearing in Article 70 proceedings when detention is by virtue of a mandate. The court shall not adjudicate the issue until written notice of the time and place of the hearing has been served personally 8 days prior to the hearing or in any manner or time as court may direct or may order. All right, question 27. This says, pursuant to CPLR 7011, the Attorney General may appeal in the name of the state in every case where the district attorney might do so. 28. 7009. In an Article 70 proceeding where a person is detained by order of the family court, notice of the proceeding must be given to the family court judge or when there's a proceeding pending in the family court. But the point is they have to give notice to the family court judge or whatever judge, and that judge gets represented by the Attorney General. And I also read in there that if the Attorney General represents him and the judge or whatever decides not to show up, that whatever comes out of the proceeding is binding on him, even if he chose not to appear. Okay, question 30. This is 6311, and it's true. A preliminary injunction may be granted only upon notice to the defendant. Notice of the motion may be served with the summons or at any time thereafter and prior to judgment. 31. 6311 sub 1. This is another true statement. A preliminary injunction to restrain a public officer, board, or municipal corporation of the state from performing a statutory duty may be granted only by the Supreme Court at a term in the department in which the officer or board is located or in which the duty is required to be performed. So that says department, not judicial district. I don't know if they're the same thing or not, but this thing says department, and this is talking about a preliminary injunction to restrain a public officer, board, or municipal corporation of the state from performing a statutory duty. And you have to do that in the Supreme Court, in the department where the officer or board is located or where the duty is supposed to be performed. All right, question 32, 6311 sub 2. Notice of a motion for a preliminary injunction to restrain a state officer or board must be on notice to the defendant or respondent and must be served upon the Attorney General by delivery of such notice to an Assistant Attorney General. That was number 32. Number 33. 6314. A party enjoined by a preliminary injunction may move at any time on notice to the plaintiff to vacate or modify it. 7802. The term body or officer includes every court, tribunal, board, corporation, officer, or other person or aggregation of persons whose action may be affected by a proceeding under Article 78. But I guess not a union? Question 35, 8018 III, in an action to foreclose pursuant to Real Property Action and Proceeding Law, Article 13, in addition to the regular fees, clerk shall also collect another fee of $190. Okay, so wow, foreclosure action, you gotta pay an extra fee of $190. Question 36. This is 8020 sub F. For issuing any certificate, the county clerk shall collect a fee of $8 if it's in New York City. So within New York City, $8, and in other counties, a fee of $4. So that's for issuing any certificate. Question 37. For a certificate of exemplification, exclusive of certification, the fee in New York City is $25, and for other counties, $10. 38. 8004. Except where otherwise prescribed by statute, a receiver is entitled to commissions not exceeding 5% upon the sums received and disbursed by him, unless a judgment creditor is appointed receiver, then he doesn't get a fee. 8004. If the commissions to be received by a receiver total less than $100, the court may allow him to get a sum not exceeding $100, as shall be commensurate with the services he rendered. Okay, so then officer. Okay, next. Ooh, which one was that? Oh, okay, here we go. 8009. This is question 40. Any authorized officer is entitled to the following fees for services specified: for administering an oath or affirmation and certifying it. When required, $2. So he basically gets $1 for each service. For taking and certifying the acknowledgement or proof of the execution of a written instrument, $2 for one person, $2 for each additional person, and $2 for swearing each witness. 8001. Each person whose attendance is compelled by subpoena shall receive each day's attendance fee of $15 and 23 cents a mile for travel expenses. Oh, I'm not going to get to the next question here.